Hello again, welcome to Module 2 for Marriage and Family Ethics. We're doing Woody and Woody chapters 2 and 3. Please remember to review both the syllabus that you need to be writing Case Analysis 1. Even though it's not due until the end of this course, we are making the effort to help you structure your time if need be, so that the assignments are ready by the time the deadline approaches. Also, in your online classroom, please access the rubric for each of the case analyses. Make sure that you are following the rubric as closely as possible, because that's what we follow when we give you the grade. So looking at Chapter 2, protecting and benefiting the client, the therapeutic alliance, informed consent, and confidentiality. On page 14, the AA-MFT Code of Ethics that directly relate to confidentiality are 1. Responsibility to clients, confidentiality, professional competence, and integrity. Familiarize yourself with those 3 sets of documents within the Ethics Code, those tenets. In Principle 1, Responsibility to Clients, specifies MFT therapists have as their major responsibility in therapeutic services to put the welfare of families and individuals first. Families and individuals are understood to have 7 inalienable rights. They are the right to non-discrimination across any domain, for any reason. The right to give informed consent. Informed, I understand it. It's written down, but you also took time to explain it to me in clear, concise, specific layman's language. That I am over the age of 18 and that I have mental capacity to enter into legal consent. That does not stop you from giving the right to assent to an elderly client, an adolescent client, a developmentally disabled client that shows great respect. However, also follow that up with someone who is authorized to give legal consent in your intake. Protection against potential exploitation by the therapist. No dual relationships, no multiple roles, multiple relationships, or at least, depending if it's just absolutely unavoidable, which in small towns, in certain situations may be the case, the responsibility to maintain those clinical boundaries, ethical boundaries, is on the therapist, not on the client. Protection against any kind of sexual intimacy or exploitation. Protection against risk involved in that kind of intimacy. And some ethics codes will say 2 years, 5 years, 7 years. The reality is once a client, always a client. And all ethics codes are moving toward that protocol at this point. The right to make their own decisions about their own lives. The right to autonomy without imposition of other values. And the right to beneficial, non-harmful services. The safeguards are a reminder list for those things. If you are looking on page 16 and the 3 basic tenets of a therapeutic contract, contracts must be non-discriminatory. Again, discrimination against clients for any reason is absolutely unacceptable. The right to autonomy and the right for beneficial services. Even though the repetition is there in the language, and in an ethics course they overemphasize these same basic principles, the idea of taking an MFT ethics course is for those things to be overemphasized and to be taught repetitiously until they're internalized and you don't have to think about it anymore. A lot of times in couples counseling, marriage and family therapists find themselves aligning with one partner or the other. Sometimes one partner seems to be more right. You have formed a stronger therapeutic alliance with that one partner. If you're going to provide services to both people, you have to understand the couple is the client and the partners are individual components of that whole couple system. If you cannot maintain boundaries, if you cannot maintain unconditional positive regard for both partners in that couple relationship, the step for that is to also associate other counselors and let each one of those have individual therapy as well. So looking at page 16 and 17, monitoring understanding, awareness, intentionality around our own personal values, biases, areas where we conflict with client behavior, things, again, around value-laden decision, divorce, same-sex, abortion, adoption, issues that are directly related to our personal or societal morals, values, faith system, beliefs. Those things are not allowed to contaminate the counseling relationship, because at the end of the day, we get in our cars, go home to our lives. Our clients have to go home to the decisions that they make. If we simply don't like someone in a relationship, a couple relationship, it's never okay to advise a client to divorce. We weren't there when they entered into the marriage or the couple contract, and we're not there to make a decision about whether that relationship remains or how it changes or how it looks. It's the client's relationship. We're there to help them process options, consequences, choices, decision-making skills, problem-solving skills, communication skills. However, that varies when we're looking at things like child abuse, mandated reporting issues, domestic violence. We never normalize issues of harm to a client. We never say, well, it's a choice. While you can promote compliance for a client to leave a domestically violent relationship, and they are adults making their own decisions, the children are living in that home fall within mandated reporting status. And you can very clearly let the clients know that, and offer safety plans and crisis plans for clients that find themselves in that situation. Domestic violence issues are never appropriate for couples counseling, because by definition you've put the weaker partner, the more vulnerable partner, into danger. So, if you need to be able to contact that client, contact them when their partner is at work, when they have a safety net in place to be able to hear from you what possible community resources are open to them. Again, looking at page 17 through 20, how you speak to or communicate a clinical intervention to a client who's facing a life decision. For myself, I would always clarify to the client that it's not my life. Obviously, I'm not the one who's facing pregnancy and raising a child at 15, 17, unmarried. You know, this is something that if we can we find the father of your child? Can we bring in some family therapy with the family that is there to support you? Is there someone there that's just to support you? What are the options? What are the consequences? How do we make a decisional balance between all these varied options, and how do we assist? Always careful to let the client know that we're there to assist them with making the decision, but we're never there to make the decision for them. In areas of custody and divorce, MFT clients are given very specific parameters in the ethics codes, as we are mandated to serve the family. And seeing one parent with a child while the other parent is being vilified, and we're thinking about gathering ourselves together to testify in court against a parent we've never met before, never counseled before, never spoke to the phone, that may or may not have informed knowledge that their child is even being seen in our practice. It's a surefire way to involve yourself in a lawsuit, and often one that cannot be won. So a clarity of purpose and view from the outset with all clients is we're family therapists, and we see families as a whole, and if we're having these issues, the door has to be open to the other partner. May cut down on some parents who are seeking you for litigation purposes only. Page 20 to 22, ways that therapists can ensure professional services are being delivered and being delivered beneficially. Or they give you a case study on page 20. They talk about the AAMFT Code of Ethics that the client not only deserves beneficial treatment, but they have a right. They have a right to beneficial treatment. And always explaining to your client that we're not there to give advice or tell them what to do. We're there to help them understand what they think would be the best fit for their life and how they would make that come to pass. The 5 necessities of informed consent, these are based in legality. They're based in the legal code of the state in which you live. And generally, across state laws, it says that the client has to have the capacity to consent, mental capacity, and over the legal age to enter into a contract, because that's what a legal consent, informed consent is. And they have been adequately informed of the information. It has to have identifying information. And if you'll look on our website on our online classroom under resources, you will see an example of a legal consent form. Those have the client's identifying information: name, address, date of birth, last 4 of their social. That it's not any Joe Smith. It's this particular one. Your name, your address, the name of your practice, your phone number, your email, your contact information. Who the information is being delivered to, who it is being shared with. 1 informed consent release of information for each single person that it's going to. That it has to have the purpose for the treatment and the reason why it's being asked. When you're also looking at informed consent, you are looking for things that I understand the negatives, the positives, what is going to happen to me within treatment processes. I understand risk and benefits. I understand that I can enter into this freely without undue influence. And I can consent that it's been appropriately documented. It's not written down. It certainly didn't happen. Informed consent and release of information are being discussed dually in this particular discussion because they go together hand in hand. So we'll have a copy of an informed consent, a copy of release of information for you to look at on the classroom. Beyond those basics, it is very essential that you speak to them and gain a verbal understanding as well as just a written understanding. There have been issues in the courts where the client says, I signed it, but I really didn't even know what it was. It was in a whole bunch of papers with in the intake, and no one ever talked to me about it. Looking at page 24, some theoretical models, particularly very directive models, may not believe that informed consent is necessary, or it may contravene the tenets of that particular theoretical model. My advice to you would be to follow the laws in your state, the ethics codes in your state, which say informed consent and releases of information are legally, ethically, clinically, and morally required. And follow your theory more strictly in other areas. Third-party requests for informed consent. It's insurance companies who want to be paid, third-party payors, the court systems, the caseworker for a defects case plan. These things are in your client's best interest. Their medical doctor, their psychiatrist, the psychologist who conducted an evaluation or an assessment procedure. Those things are in your client's best interest, but your client still has to consent. It's not our job to decide what's in their best interest. We can point out the benefits of those things, but ultimately it's their choice. However, if I wanted to get paid and a third-party payer consent was needed, I would have that already in place in my informed consent. Other things that are outside of those basics, an attorney requesting information, seeking a subpoena, those things are handled one-on-one. Always access your professional organization, the policies and procedures of your agency, what the ethics codes say. Associate a legal opinion from an attorney prior to making a decision to break the client's privilege just on your own knowledge of the situation. Consultation and supervision around these issues are crucial to good success. Alliance issues unique to marriage and family are discussed on page 26 through 28. And in those therapeutic relationships, if we bond to the couple, bond to the family, bond to the most vulnerable party in the room, the 1-year-old baby without a voice, it is much easier at that point for us to clarify our stance. Also, the other issue that's necessary for us as clinicians is to come from a stance of awareness, intentionality, to check ourselves for countertransference issues. We may not like nagging wives, bossy husbands, whining children. It has nothing to do with the client's family that's in distress that sits before you. An awareness and intentionality and mindfulness around our issues will clarify and solidify our stance as we try to help this family. If the countertransference issues are so severe that we're not able to provide quality clinical services, at that point a referral is necessary, and possibly doing our own work around why those issues triggered us to the point that we couldn't offer services to that particular client. Looking at page 29, to clarify confidentiality, privilege, and privacy. A clear operational decision-making model around what is confidential for your client and where their privacy starts and stops can be facilitated if you have sort of a definition, a working definition in your mind. For me, confidentiality is based around what happens in the counseling room. What is the clinical information that's communicated between me and the client during session? Privacy lives within confidentiality, is part of confidentiality, but I tend to think of privacy more as a client's name, date of birth, social security number, insurance payment, cell phone, work address, credit card numbers, things that need to be protected but are not necessarily clinically confidential, but still have to be protected under the umbrella of privacy. Privilege is a legal term, and privilege speaks to who holds and who owns the confidential private information. The answer is always the client. If you break it because you're a mandated reporter and you find yourself in that situation, you're breaking the client's privilege. There's a legal mandate for you to do so, but you're still breaking the privilege. If you turn it over to the insurance company to be paid, you have client permission to break the privilege, but you're breaking it. If you are at a witness stand and a federal court judge orders you to answer the opposing attorney's question about your client, you can turn to the judge and say, "Your Honor, I respectfully uphold the client's privilege." If he orders you to do it, it's in the record, you're protected. But we still acknowledge as therapists that the privilege belongs solely and wholly to the client at all times, regardless of other actions. Going into how to resolve conflicts between legal issues and ethical issues. It's important to remember that the legal code keeps you in compliance with state law. If you break the legal code, you put yourself at risk of going to jail, of being incarcerated. The ethics code are what someone wrote down, a body of people wrote down a body of information in written form that says this is the bare minimum that you can do to be considered ethically responsible within our professional field. Bare minimum standards, both of them. Legal code keeps you out of jail, ethics code keeps your license on the wall. Neither of them are virtue ethics, principle ethics, aspirational ethics, moral ethics. Those are the letter of the law, not the spirit of the law, and it is the least that you can possibly do, not the most that you can possibly do, not above and beyond. So understanding that you must follow the legal code, but if your ethics code asks that you go past the legal code, as long as you're not breaking the laws of your state, then we follow the ethics code and do more than. If we have further questions about that, we can discuss that more in depth, but that's the generalized discussion of that. Looking at Tarasov, Tarasov gave rise to the duty to warn law that most states have adopted. Georgia is in process of adopting duty to warn. It currently is duty to protect. Duty to protect is less robust. In order to have duty to warn, based on the Tarasov case, you must have an identified victim. In those situations, the absolute best option is to notify two people, the police and the person that you feel is imminently being victimized. Example, if you had a client in your office who said, my wife's been cheating on me and I'm not geared to that and I'm going to put it into it. After today, she won't be allowed to cheat on anyone. You know who his wife is, you have the address, you have the phone number, you have a valid threat. Two things have to happen sort of simultaneously. One, law enforcement needs to be advised so they can go out, hopefully make a presence, do a wellness check. Different responses can be given. One officer may be willing to go out and take a police presence there in order to protect a citizen who's been threatened or view it as a terroristic threat. A different officer may say, I'm very sorry, there's nothing we can do until something has already occurred. At that point, you would ask to speak to a supervisor, you would get names, badge numbers, you would document dates, times, you would let that officer know that you were documenting his exact response and what you had reported and his failure to act upon that response. Usually that will get some kind of action. Secondarily, a phone call needs to be made to the identified victim with a clear warning without causing total panic. An example of that kind of phone call would be, hello, this is Shannon Eller from Brighter Tomorrows Consulting. I'm very concerned for your safety at this point. Your partner has left the session in a very agitated, seemingly violent state of mind. I'm concerned for your safety, the safety of your children. I really would wonder if you could leave, go to some safe place, a neighbors or friends, call 911, but not be in the house when they arrive until we can see if this issue can be de-escalated. And try to stay on the phone until you see that that has occurred. Just for the sake of this discussion, to go back over the issues of Tarasov, these two students were in counseling at the University of Southern California about their relationship. The relationship went sour. The female in the relationship ended it. The male in the relationship continued counseling. The parents of the girl took her out of this country, and he continued continued counseling at the counseling center that was provided by the school. One day he said, I'm through. If she's not going to have me, she's not going to have anybody. If she can't make up with me and I can't have her for my girlfriend, then I'm going to kill her. They reported it. They reported it to the campus police, to the dean, to the director of the counseling center. The girl comes back in from the country, goes into her dorm room. He makes good on his threat. He goes over, he kills her, and the parents sue for wrongful death. The school counters and says, no, we did report it. We reported it everywhere to everyone. They said, you did not report it to us. We could have kept her out of the school. We could have kept her out of the country. We could have kept her alive. You did not report it to my daughter where she could escape. We now have a dead child. A dead client is hard to overcome. So you're not going to be pinged for doing too much as quickly as you will be for doing too little. You have mandated reporting protection status under the law, and understanding the difference between real threats and perceived threats comes with clinical practice. So it will be interesting to see some of the case analyses possibly that go around that particular issue. Mandated clients with confidentiality. Mandated clients by definition have diminished confidentiality, but they still have confidentiality. As part of their treatment, they may be required by outside forces, outside resources, to have allowed DFACs or their probation or parole officer to have access to some of their treatment records. That doesn't mean that they have zero confidentiality. There's a large difference between reporting dates of counseling sessions that they attended, treatment compliance, versus every single thing that was said within session. So there has to be some common sense and some rational decision making around that. On page, let's see, 35 to 37, that particular issue talks about the concern to the right of privacy, in that they give you an actual case number, a book that called The Right of Privacy by Ellen Alderman and Carolyn Kennedy, other case numbers from the Harvard Law Review that have gone before the Supreme Court. You can certainly read that and look at those for more information. Jaffe versus Redmond is a case that is on the MFT test, at least it was on the one that I took, on page 37. And it talks about recommendations for defining how confidentiality and communications between marriage and family therapists and a client. The U.S. Supreme Court recognized the effectiveness of therapy was dependent to some degree on client reliance on confidentiality, and that you have the right to give judicious disclosure even in court. That basically relates to you don't have to tell every single thing that you know, or every single thing that they've told. You tell things that are there to protect the rights of the client, others, and the community. Rights of mandated population, of mandated clients, the rights of vulnerable populations in mandated reporting situations. If you are asked for information from outside sources that violate or could potentially violate a client's confidentiality, consult, seek supervision, seek your professional organization's opinion, seek a legal opinion, go to the policies and procedures, again, of your agency. Do not do it quickly, do it slowly, and make sure that you know what position you stand. Looking at Witty and Witty Chapter 3, which will be the end of this particular Module 2, looks at multiple relationships. On page 44, multiple relationships are defined as situations where you are functioning in a professional relationship and some other relationship. You might go to church with these people. You might have a child playing on the same sports team with your client. You might live in a very small town. Some cannot be avoided. Again, on the therapist to set those boundaries. Professional boundaries are understood as a frame or time limit that excludes or includes the therapeutic relationship. Maybe I will not go to this prayer meeting, this small Bible study with my client for a period of time while they're active. There's a difference between boundary crossing, boundary violation. An example of a boundary crossing may be that I continue to allow my child to stay on the same soccer team, but I certainly understand that at the game I'm a soccer mom. Boundary violation is when you engage in or allow your client to engage in discussion around their treatment issues at the soccer game in an open forum without the proper confidentiality boundaries in place. Types of multiple relationships on page 45. Personal friendships. Best not to counsel your friends and relatives. That's pretty simple. Things with social interactions. Typically, clients are understood to be clients and not friends, so birthdays, weddings, bar mitzvahs, babies' baptisms, while they're nice things, safe rule of thumb is to not go. The only place that we interact in social interactions and events with a client is if a client has died while they're one of our clients or a previous client has died. You would never enter into business or financial relationships, into professional relationships, even if they're a client who later decided they wanted to become a counselor, refer them out for supervision. Don't muddy the waters. And religious affiliations, again, going back to the same church, easier in large town with many churches, harder in small towns with a few churches. We don't engage in workplace relationships, collegial relationships. And in the society that we live in, particularly with Facebook is not a place to accept friendship requests from clients unless you're looking for issues that are very difficult to deal with after the fact. Looking at page 44 on sources of therapeutic power, it's really kind of simple. We typically have more education, typically have our own offices. We have situations that allow us to have a power differential. If we can sign a piece of paper that allows our client to get their driver's license back, that allows them to complete their defects case plan and get their children back, that allows them to be able to be freed from probation supervision, carries a lot of power. Our signatures and our recommendations carry a lot of power. Our clients are aware of this. We need to be as aware of this as they are and realize that there's not a place to do friendship or professional relationships while this is occurring. Looking at the sub-principle related to sexual intimacy, that's in the MFT code, as are the 8 categories of non-sexual post-therapy relationships, which are the friendships. Look at the rationale is pretty clear. Page 47, the 4 principles foundational and boundary regulation in therapy. Former clients might need to come back to therapy if you've made them into your friend. Might make it difficult. There's a variety of clients that stay vulnerable all of their lives. They're chronic clients, and it's very unfair to them to put them in a situation. Sometimes the transference with clients toward their therapist is extremely high with very strong feelings. And sometimes we have to come back and furnish records. So looking at these types of issues will give you a very strong marker for those things. 8 reasons for limiting multiple therapist-client relationships are also listed between page 47 and 48 that you're able to look at and read yourself. Looking at role theory on page 49 and 48, look at Kitchener, 1988. The incompatibility of expectations that increase between roles, the power and prestige between professional and clients' roles, the potential for exploitation, the potential for loss of objectivity. Finishing this are the rural communities. Small towns sometimes have to have